The ground just shifted. And it didn't just shift in a courtroom in Lower Manhattan. It shifted under the very foundation of the current American political infrastructure. At exactly 4:12 a.m., a document was filed that makes the previous 4 years of legal maneuvering look like a mere preamble. We're talking about the kind of forensic evidence that doesn't just suggest a pattern. It creates a map that leads directly to the inner sanctum of the 45th and 47th President of the United States. And the person holding the map, it is the very person who was supposed to be the gatekeeper, the firewall, the loyalist of all loyalists. According to a 214-page transcript released late Friday, Pam Bondi has flipped. And she didn't just flip, she brought the receipts. We're talking about $127 million, 14 separate contracts, and 3 shell companies that were designed, according to the filing, to be invisible to federal oversight. But they aren't invisible anymore, because on Thursday morning, in Courtroom 14B, the former Attorney General didn't just take the stand, she handed over the keys to the kingdom. To understand how we got to this explosive moment in March of 2026, you have to understand the specific trajectory of Pam Bondi. This is a woman who wasn't just a supporter, she was a pillar of the MAGA legal establishment. From her time as the Florida Attorney General to her nomination as the U.S. Attorney General in late 2024 and her subsequent confirmation in early 2025, she was the primary shield against every subpoena, every investigation, and every inquiry directed at the Southern District of New York. For months, Bondi was the firewall. If the Department of Justice wanted a thread, they had to go through her. If a prosecutor wanted a wire transfer, they had to ask her office. But something happened between January and last month. The Southern District, they started pulling at threads that weren't just political, they were financial. Real estate deals, foreign payments, LLCs registered in Delaware that existed on paper but had no physical footprint in the real world. And when the federal investigators finally issued subpoenas to 3 specific holding companies, the firewall began to crack. Now, look at the timeline. It is a timeline that moves with the velocity of a high-speed collision. Weeks ago, Bondi's personal attorney met with prosecutors twice in secret. By Monday, an immunity deal was signed. And by Thursday, she was sitting in that witness chair, not as a target, but as a cooperating witness for the United States government. This is a cabinet-level official, the former top law enforcement officer in the country, testifying under oath about the person who appointed her. And the testimony? It is devastatingly specific. According to page 34 of the filing, Bondi confirmed she had direct knowledge of 3 separate agreements executed between January 2025 and August 2025. These weren't handshake deals. These were executed agreements involving payments routed through intermediary entities, what the rest of us call shell companies. Bondi didn't just hear about these payments, she watched the money move. But it's page 89, paragraph 47, that provides the smoking gun for anyone following the money trail. Bondi testified that she personally reviewed wire transfer confirmations totaling $18.2 million sent to a Nevada holding company. Now, here is the part where the analysis meets the evidence. If you go through the Nevada corporate records, as we have, that specific company was registered exactly 6 days before the first payment arrived. And it was dissolved exactly 11 days after the last payment was sent. This wasn't a business. It was a conduit. It was a pop-up shop for $18 million. And we have to talk about the emails. Because in the digital age, The paper trail is made of pixels. According to Exhibit F, page 112, Bondi handed over 47 emails between herself and 3 members of the inner circle. The subject lines alone, which are now part of the sworn record, include the words rapist's arrangement and offshore structure urgent. Read that again. The Attorney General of the United States was receiving urgent emails about offshore structures while she was sitting in the Department of Justice. This is where the safe framing of the legal system comes into play. These are unanswered legal questions, but they are questions backed by exhibits. The communications didn't stay on official servers. When the topic shifted to these offshore structures, the inner circle moved to encrypted platforms. But it didn't matter, because the banking records, the wire confirmations, and the time-stamped communications already existed in the hands of the prosecutors. Now, look at what is buried in the appendix. Page 147. This is the detail the mainstream headlines are missing. Bondi testified about a specific meeting at Mar-a-Lago in February of 2025. There were 8 people in the room. And according to her testimony, she was instructed explicitly not to document the conversation. She documented it anyway. She kept personal notes at her residence. Notes that were turned over to federal prosecutors last month. And those notes, they reference a $340 million development deal involving a foreign sovereign wealth fund. And the structure of that deal, it was architected specifically to avoid what is known as a CFIUS review. For those who don't spend their lives in the weeds of federal regulation, CFIUS is the Committee on Foreign Investment in the United States. It is the body that reviews deals that could impact national security. Bondi's notes, which are now Exhibit B4, include a direct quote that should send a chill through every oversight committee in Washington. The phrase was, "They know the threshold. Stay under." That is the sound of a deliberate attempt to evade national security oversight. The fallout was instantaneous. By Friday afternoon, 3 additional subpoenas were issued. 2 went to former White House staffers. 1 went to a current member of the president's legal team. The Nevada LLC is now the subject of a full federal investigation, and the clock is ticking for international institutions in the Cayman Islands, as prosecutors have requested banking records to be delivered within 72 hours. But let's be fair, because even in an investigation this explosive, there is a defense. The president's legal team, led by attorneys who have been in this fight since 2019, are calling this political persecution. They argue that Pam Bondi is not a neutral witness. She is someone who cut a deal to save her own skin. And when you have an immunity deal, your incentive structure changes. You have a reason to deliver what the prosecutors want to hear. They also argue that complicated does not mean criminal. Offshore accounts, Delaware LLCs, Nevada holding companies. These are legal structures used by thousands of legitimate businesses every day. A former federal judge now at Georgetown Law noted on Friday that the complexity of a transaction does not prove intent. You need more than just a structure, you need a crime. And then there is the emotional angle. In the world of MAGA, loyalty is the currency of the realm. Republican strategists are already framing this as the ultimate betrayal. Bondi was family. She was a true believer. And for her to flip, for her to bring physical documents, emails, and notes to the very people trying to dismantle the administration, it feels personal to those who trusted her. But as an analyst, I have to look past the feelings and look at the paper. You can question a motive, but you cannot question a wire transfer confirmation. You can attack a witness's character, but you cannot attack a time-stamped email. If this were just her word against his, the defense would have a solid point regarding reasonable doubt. But it isn't just her word. It is a paper trail that has been handed over by the person who was in the room. How did this fracture happen? It didn't start Thursday. It started a year ago, when Bondi and the Inner Circle disagreed on how to handle subpoenas from the Southern District of New York. Bondi wanted compliance. They wanted delay. Months later, she was sidelined. She kept the title, but she lost the access. And when her name surfaced in a parallel investigation around the holidays, she saw the walls closing in. She made a choice. She watched what happened to Michael Cohen. She watched what happened to Rudy Giuliani. She watched what happens when you stay loyal past the point of legal safety. And because she had cabinet-level access, she had conversations that never should have happened in front of a potential witness. The question people are asking is, why? Why keep the notes? Why save the emails? Maybe it was insurance. Maybe it was instinct. But on Thursday, at exactly 2:47 p.m., it became testimony. Bondi was asked about a specific meeting in the Oval Office on February 14th, 2025. She paused, she looked at her attorney, and then she said the words that made the room go silent. She said, "I was present when the president discussed structuring the Doha Agreement to avoid congressional notification requirements." The Doha Agreement, a $340 million development project in Qatar, foreign financing, American partners, and a specific instruction to keep it below reporting thresholds. But here is the revelatory thread you need to hold on to as we move into part 2. While the media is focused on the dollar amount, they are missing the names. Bondi didn't just name the president. She named 8 people, including current officials and 1 sitting member of Congress. The transcript of that section was partially sealed within an hour, but the shockwaves are already hitting the Hill. On Friday morning, one of those names lawyered up publicly. He hired a white-collar defense firm in D.C. and issued a statement denying wrongdoing before anyone had even publicly accused him. That is telling. Judge Mercer has now scheduled an emergency status hearing for Tuesday, March 10th. Something in that sealed testimony spooked the court into moving at an accelerated timeline. The legal machinery is moving, and it is moving toward a collision. The narrative isn't just expanding, it is accelerating toward a point of no return. As we move into the second hour of this forensic breakdown, we have to look at the sealed portion of that Thursday transcript, the 2.5 hours of testimony that Judge Mercer deemed too sensitive for the public record. But in Washington, nothing stays buried forever. While the media was chasing the $127 million headline, the legal machinery was grinding through the names that Bondi dropped under oath. According to sources close to the filing, the reason for the seal wasn't just national security. It was ongoing investigations into current members of the United States Congress. We are talking about a specific sitting congressman, someone whose name is currently redacted, who allegedly acted as the legislative cleaner for the Qatar development deals. Look at the geography. We aren't just in D.C. anymore. The paper trail spans from the Oval Office to the Cayman Islands and straight into the sovereign wealth funds of Doha. According to Exhibit C, which remains under a protective order, Bondi provided bank routing numbers that show a constellation of payments, not one lump sum, but hundreds of smaller transfers designed to stay below the $10,000 reporting threshold required by the Bank Secrecy Act. But it's the 4 a.m. meeting that changes the calculus of intent. Bondi testified that on February 14th, a date now etched into the trial record, she was summoned to a private residence. There were no official logs, there were no Secret Service transcripts, but there was a personal notebook. Bondi's notes from that night describe a conversation where the president allegedly discussed the necessity of bypassing congressional notification for the Doha Agreement. The phrase she recorded, "I was instructed not to document the conversation. I was told this explicitly." Then she documented it anyway. If that note is verified, and prosecutors are currently cross-referencing it with encrypted metadata recovered from Bondi's devices, then the executive privilege defense isn't just weak, it is functionally extinct. You cannot claim privilege over a conversation that was architected to subvert federal law. And then there is the Mar-a-Lago appendix. We now know that the $340 million development deal wasn't just a real estate play. It was, according to the documents handed over by Bondi, a reciprocity arrangement. Exhibit F2 contains an email chain where a senior staffer asks about offshore structure, urgent. The subject lines included, direct quote from the transcript, rapist arrangement and offshore structure, urgent. This is the smoking gun that the Southern District of New York has been hunting for. It suggests a quid pro quo that isn't based on hearsay, but on the digital fingerprints of the people in the room. While the president's legal team continues to frame this as vengeance by a disgruntled employee, the Department of Justice is moving with a speed we haven't seen in decades. Friday afternoon, at exactly 4:12 p.m., the DOJ requested expedited discovery from 4 international financial institutions. They aren't waiting for the Tuesday hearing. They are already seizing the servers. But the question remains, why did Pam Bondi wait until March of 2026 to bring this forward? The answer lies in the immunity deal. Bondi wasn't a hero who woke up one day with a conscience. She was a target. Sources indicate that federal prosecutors had already linked her signature to 2 of the Nevada shell companies months ago. She was looking at a potential 20-year sentence for money laundering and conspiracy. She made a calculation. She chose to trade the inner circle for her own freedom. And that is where the danger lies for everyone else named in that transcript. Because if the Attorney General of the United States can be flipped, then no one is safe. On Friday night, Republican leadership went notably quiet. There were no defiant press conferences on the Capitol steps, just a single senior senator telling reporters, "We need to see what's in the sealed documents." That is the sound of a political establishment preparing for impact. To grasp the full weight of the evidence, we have to look at Exhibit F. Bondi provided prosecutors with 47 emails. These weren't just casual check-ins. These were communications sent while she was the sitting Attorney General. The subject lines alone, according to page 112 of the transcript, prove that the conversation shifted to encrypted platforms the moment the topic of offshore structures arose. And then there are the Nevada corporate records. The company in question was registered exactly 6 days before the first payment arrived. It was dissolved exactly 11 days after the last one. As Bondi testified on page 89, paragraph 47, she personally reviewed wire transfer confirmations totaling $18.2 million sent to this Nevada entity. This entity had no employees, no office, and no apparent business purpose. This is what architected money laundering looks like. This isn't sloppy work. It is high-level financial engineering designed to hide the source of funds. And who were the players? Bondi named 8 individuals directly. Another 15 are referenced by title or description. The public doesn't know their names yet, but the prosecutors do. Federal employees in related agencies are already receiving legal hold notices. The instruction is clear. Preserve all documents. Do not delete anything. This hits the desk of every official on Monday morning. But the most chilling part of the testimony isn't the money. It's the intent to obscure. Bondi testified that the $340 million Doha deal was specifically structured to stay under the radar of the Committee on Foreign Investment in the United States, CFIUS. If you are wondering why you should care, it's because CFIUS reviews deals that could impact national security. When you hear the phrase, "they know the threshold, stay under," you are hearing a blueprint for evading the very systems meant to protect American interests. The legal machinery is now moving against the international institutions involved. Prosecutors have requested banking records from 4 international banks, including one in the Cayman Islands. The clock is running. They have 72 hours from the time of Bondi's testimony. And while Trump's defense calls this a disgruntled former employee seeking leniency, legal experts say otherwise. A former assistant U.S. attorney with 17 years at the SDNY put it plainly. When a cabinet-level official flips and brings contemporaneous documentation, that's an earthquake. You can attack a witness, but you can't attack a wire transfer confirmation. Even Republican strategists are feeling the ground shift. Bondi wasn't just an ally, she was a true believer. Her flip feels like a personal betrayal to the movement. One former campaign official called it unforgivable. But the documents don't care about loyalty. They only care about the paper trail. The calculated self-preservation that Bondi displayed is a pattern we have seen before. Loyalty is rewarded until it becomes a legal liability. Bondi watched Michael Cohen, she watched Rudy Giuliani, and she decided she wasn't going down with the ship. The difference this time is access. Bondi had cabinet-level access. She had classified briefing access. She had access to conversations that should never have happened in front of a potential witness. And now, prosecutors have all of it. At exactly 2:47 p.m. on Thursday, the Oval Office meeting from February 14th, 2025 was laid bare. The Doha agreement wasn't just about development. It was about congressional notification requirements and how to avoid them. When the room went silent after that revelation, the reporters scrambled. Within 23 minutes, the news was out. And yet, the media still missed the biggest part. While they focused on the $340 million, they missed the congressman. Bondi named a sitting member of Congress. We don't know who yet, but their office is refusing to comment. They lawyered up before the names were even public. That fast. Judge Mercer's emergency status hearing for Tuesday, March 10th, is where the next phase begins. The sealed portion of the transcript is the prize. Prosecutors requested the seal to protect something or someone. Is there another witness? Are there more indictments coming as early as this month? In part 3, we are going to dive into the specific congressional names. We are going to look at the March 12th policy shift that the emails referenced. And we are going to look at the one document that Bondi says is the insurance policy she kept in a vault in Florida. The legal machinery is in motion, and the next 72 hours, they are going to rewrite American history. The legal machinery isn't just grinding anymore. It is at a full throttle, high-velocity scream. As we enter this final hour of our investigative deep dive for the political update, we have to look at the March 12th policy shift, a date that appears in the encrypted emails Pam Bondi handed over to the Southern District of New York. According to Exhibit F2, page 112, there was a direct question from a senior staffer. Does the Qatar financing clear the way for the March 12th policy shift? The answer was a single devastating word: affirmative. But what was that shift? According to Section 12 of the internal memo filed under seal, it wasn't just about real estate. It was about executive privilege being used as a tactical weapon to shield private financial arrangements from the Committee on Foreign Investment in the United States, or CFIUS. Bondi's notes. which she kept at her private residence and turned over to prosecutors last month, contain a phrase that changes the entire legal landscape. They know the threshold. Stay under. This is the insurance policy Bondi kept in a vault in Florida. And then there is the congressional connection. While the headlines were screaming about $127 million and 14 separate contracts, the real earthquake was happening in the redacted names. Bondi didn't just name the president. She named 8 people, including a sitting member of Congress. According to the transcript, this individual was present during the Oval Office meeting on February 14, 2025, where the structuring of the Doha Agreement was discussed to avoid notifying the very body he serves in. Look at the reaction on the Hill. At exactly 9:14 a.m. Friday, the congressman's office issued a no comment. But by 11:30 a.m., he had already hired a white-collar defense firm out of D.C. He volunteered a denial before the public even knew he was the one in the transcript. That is the sound of guilty anticipation. But we have to look at the 30 to 35% new data that is just hitting the dockets at DOJ.gov. Federal prosecutors have now requested expedited discovery from 4 international financial institutions, including a massive request to the Cayman Islands within 72 hours of Bondi's testimony. Why? Because Bondi provided the routing numbers. She provided the account names. She provided the timestamps of the $18.2 million sent to a Nevada holding company that was registered 6 days before the payment and dissolved 11 days after. This wasn't just a disgruntled employee seeking leniency. This was architected concealment. Even legal analysts who have defended the administration in the past are looking at Exhibit B4 and seeing a point of no return. A former assistant U.S. attorney with 17 years at the SDNY noted that when a cabinet-level official flips with contemporaneous documentation, that isn't a wobble, it's an earthquake. You can question Bondi's motive. You can call her a traitor, but you cannot argue with a wire transfer confirmation. And let's be clear about the safe framing here. These are currently unanswered legal questions. The defense argues that Bondi is a bought witness who needed to deliver something to stay out of prison herself. They argue that offshore isn't automatically fraud. And they are right. On paper. But in a courtroom, when the paper trail shows a pattern of deliberate evasion of national security review, the argument of legitimate business begins to evaporate. The most uncomfortable part? The calculated self-preservation. Bondi watched Michael Cohen. She watched Rudy Giuliani. She saw what happens when loyalty lasts longer than legal safety. And because she had cabinet-level access, she had access to conversations that never should have happened in front of a potential witness. As we look toward Tuesday, March 10th, the date of the emergency status hearing, the world is waiting to see if the sealed portion of the transcript becomes public. There are 2.5 hours of testimony that we haven't heard. 2.5 hours of names, dates, and receipts that were deemed too explosive for the first release. The first domino fell Thursday. The second one is midair. And the third domino is the grand jury reconvening on March 12th. If you have an investment in the U.S. markets, pay attention. On Friday, defense contractor stocks dipped 2.3% after the Qatar connection surfaced. Investors don't like uncertainty around foreign deals. Your 401k probably has exposure to companies now scrambling to review their own compliance. This is not a hot take. This is the market pricing in legal exposure. The Political Update will be watching that Tuesday hearing live. We will be reading the documents. We will be translating the transcripts. Because whether this is justice or vengeance? The evidence itself is what we focus on. The legal machinery is in motion. Bondi's testimony opened a door. And what walks through it next? We find out Tuesday.